Hi, Joel. Thanks so much for being here and talking with me today about the seller disclosure. We did this last year, I think this time last year, maybe not, but we did it last year. So thanks again for speaking with me and going through the seller disclosure law, especially now that there's a new disclosure that just got released in July. So you're going to go over some of the best practices today, share some examples. For those of you that were not there last year, Joel Albert is an attorney licensed in Pennsylvania and New Jersey. He's been practicing law for over 30 years, and he has represented both buyers and sellers in property disclosure cases in mediation and litigation. So I'm so thankful that you're here to be our expert.
Thank you for having me.
All right, good. So this kind of like the format. I'm just going to ask you some general questions. We'll have a little discussion about the seller disclosure law and recent amendments to the disclosure that is prepared. This disclosure is just to be clarified, is the Pennsylvania Association of Realtors seller property disclosure. So you're just going to share some of your expertise and best practices. So, all right, well, you ready to get started?
I am.
Okay. So first question is, what transactions are subject to real estate seller disclosure law? Here, and let me.
Okay, if you could, why don't you pull up that disclosure?
Okay. Can you see it?
Yes. Okay, so this is the first page of what Kelly was stating is the Pennsylvania Association of Realtors seller disclosure statement. And the transactions that are covered by Pennsylvania's real estate disclosure laws are listed on page 1, and I'm going to go through them. But for starters, all residential real estate transfers of between 1 and 4 residential dwelling units are covered. Now that is a mouthful, so I want to break it down for you. Number 1, we have residential. That's designed for people to live in versus commercial. Secondly, I said transfers, which is really, I guess, a fancy term for either a sale, but it could also be a lease with an option to buy. 1 to 4 residential dwelling units, we're most familiar with a single family home, but this also includes residential duplexes, triplexes, or 4-unit dwellings. When we last got together, someone asked a question about mixed use properties. And both Kelly and I have had this. And what I would say with regard to mixed use properties is the disclosure obligation only applies to the dwelling units only. So if it's like a storefront on the bottom, an apartment on the top, it only applies to the apartment or the residential dwelling.
Got it. And it's kind of similar, just so people understand, if you're getting a loan, a residential loan, it's a similar thing, a 1 to 4 unit. Once you're over 4 units, that gets into commercial. It's a different type of loan. So think of it that way, I guess, too. Commercial doesn't require this.
Right.
Okay. What types of transactions are not subject to this form?
So this is also listed right on the front page of that form. I'm going to go over the most common ones. So number 1, a transfer that is a result of a court order does not require disclosure. So if someone is awarded property. Number 2 is foreclosure sales. If you're buying from a bank, the bank does not have an obligation to disclose any material defects. Third is a transfer made to a spouse or a child, which happens often. There is no disclosure requirement there. Number 4, we also see a lot of transfers due to a divorce or a property settlement. That also is not subject to disclosure laws. transfer of unimproved real property. So just land, there is no disclosures. New construction that's never been occupied, there are no disclosure requirements. And lastly, are transfers per a will. We're going to discuss that a little later because there are instances when there could be disclosure requirements, but with regard to an executor, but those are the main categories of transactions where you are not required to make disclosures.
Got it. That's helpful. So in the process, when is it ideal that you must the disclosures must be made?
So ideally, disclosures should be made before an agreement of sale is signed. What we're going to discuss a little later on, and what this recent amendment discussed, is you also need to make disclosures as new information surfaces, such as buyer inspections. So best practices: complete the disclosures prior to listing and showing the home, and have any potential buyers acknowledge receipt and date the disclosures.
Right. And again, like continuing. So I know I reached out to many of my houses that were under contract. How's the house during Ida? Like just to make sure that everything's fine.
Right, because again, a lot of people make the disclosure and then they never amend it. But you really should, up and until the time of closing, whether you're with the same buyer or if that agreement maybe was terminated due to an inspection, and then a subsequent buyer comes along, you gotta let subsequent buyers know what you discovered.
Right. So in general, what must be disclosed about the property?
Okay, this is a biggie, and in a nutshell, the obligation is to disclose known material defects. So once again, let's break that down. Known means you must have actual knowledge of the defect. It's not that you knew, it's not that you should have known, it's you must have actual knowledge of the material defect. Now, with regard to a material defect, that is a problem with a property that either, number one, has an adverse impact on the value of the property, so it's a money issue. Or number two, it involves an unreasonable risk to people on the property, a safety issue. So Kelly and I have had numerous examples of material defects, but some of the most common are water infiltration, either from roof or stucco, mold, termites, sewer backups because of tree roots in the line, flooding, and boundary or title disputes. Some defects that are not considered material are loud neighbors, a leaky sink, sexual predators that live in the neighborhood. This comes up a lot in New Jersey with Megan's Law. And in Pennsylvania, a prior murder or a suicide in the home, which the courts have determined is not a material defect.
Got it. So as a seller, which disclosure form should be used?
So I got very excited when I saw this July amendment because I think everyone should now use the new form that you had up on the screen previously, and that was just amended in July of 2021. Right at the outset of that form, it lets everyone know that these disclosures go above and beyond is what is required under Pennsylvania law. And you and I were talking about this while we were preparing. Some of my colleagues, lawyers, are of the opinion that you only disclose what you have to. I respectfully disagree strongly. Um, and I think this form does a great job of assisting both sellers in completing it and buyers as far as understanding it. So I highly recommend this new form. As we're going to discuss later, we both feel best practices uh, really should be to err on the side of disclosure. Um, and with regard to sellers, the goal of a seller is to sell your property and to not have to worry about it again. Um, and if your disclosures are complete, then you can rest easy at night. If they're not, a buyer potentially has 6 years from the date of the sale to bring in action. So it's a long-winded answer, but I suggest people use the revised form.
Right.
Sellers.
Yeah. All right. Well, so let's get into it. So let's talk about some of the recent changes in the disclosure form.
Okay, so one of the first ones that jumped out to me, again, is right at the outset, they state that these disclosures go above and beyond what is required. Um, and again, I'm a big proponent of that. What is really significant, and we see it both in the beginning and the end of that, is that the duty to disclose continues until the date of settlement. And that language is actually boldface. And at the end of the document, it says, after completing this form, if the seller becomes aware of additional information about the property, including through inspection reports from a buyer, the seller must update the seller's disclosure statement and or attach the inspection report. And
important.
This is very important, and I think sellers typically do not do that. I have a case going on now where I represent the seller. Seller had a stucco home. Seller entered into a contract with the buyer. The buyer performed a stucco inspection. The stucco inspector recommended that all the stucco be removed and either replaced with stucco or vinyl. My client, with the assistance of his realtor, made repairs to just the areas of stucco that had a high moisture reading. Never, and then put the home back on the market, but never disclosed what was that prior stucco report or the fact that they were aware of it. Sold to a different buyer who then moved in and a couple months later started experiencing or noticing water infiltration. Discovered the stucco report that was left in the home inadvertently and brought an action against the realtor and my client. And from a defense standpoint, I've explained to my client, you're really, that report should have been disclosed. So it happens all the time. And again, I think this is one of the most important things that sellers need to understand, that duty to disclose continues until settlement. So that was the first thing that jumped out at me, both, in the beginning and the end of that. We talked a little earlier about executors. A lot of times people die, and whether it's a parent and maybe the child goes to sell the home as the executor. While executors don't have a duty to disclose, if they have knowledge of the property of a material defect, they do need to disclose. So I have a case now where my client was the buyer and bought a property from an executor. And he was provided a seller disclosure statement, but it was just lined out.
Right.
And then the property was sold. My client started to notice a bunch of problems with the property. Strangely enough, the executor came to the house post-closing to say to my guy, hey, you should be aware of these problems with the house. I know, I lived here. And he sort of felt bad because my client had young kids and he knew about mold. This was very surprising to me. We're trying to mediate this thing, but when I spoke to the seller said, my lawyers told me I should not disclose anything and just line it out. That was bad advice. And one of the amendments in July says, hey, while executors are not required to make disclosures, they must do so if they know of material defects. So this guy knew about it. He got bad advice, and now it's a problem for him.
Yeah, that's tough. I do a decent amount of states and they're like 95% of the time, nothing's ever filled out.
Right, and in this one, they just lined it out, and and even prior to this amendment, there was language that said what we just discussed. It wasn't as clear, but again, if you know of material defects, and in this situation, it was the child of two parents who had died, and he had lived in the home since the last parent died. So it was the whole lawsuit is unnecessary. It really
Right.
could have been avoided. When we last got together and did this, Kelly and I talked about what one of the questions was, is a seller obligated to search and produce records regarding the property? What Kelly and I noticed about these edits is now in the disclosure statement, in a bunch of sections, they ask the seller to identify the person or the company who did any repairs and the date they were done, whether they pulled permits. A lot of this is new, and I think this is a great edit and addition. Because while the seller specifically is not obligated to make any investigation, what you and I talked about before is best practices, I think, is to retain, search, and produce records. I think number one, from a marketing standpoint, if I'm a buyer and a seller gives me all the records, regarding the improvements and repairs, I'm going to feel a little better about that.
Totally.
If I'm a seller, I want to disclose I want to show everything, show that I took care of the house, maintained the house, improved the house. That's all great stuff. As a lawyer, when I either defend or pursue these cases, I have to track these people down to see what was done. So it makes my job easier. So throughout the disclosures, one of the edits has been to identify these people. I don't know how you do it unless you have records and a really good memory, but I would go with the records. So this was another edit that I would like to think in whole or in part maybe was a result of some of the things that we said last time.
I will say I'm not seeing a lot of them still fill it out though, which has been frustrating. But
okay, and again,
only so much you can do.
Yeah, you could only ask the sellers to do what you think is best. But again, that's in a seller's best interest, right, to do that. We noticed some other edits that were pretty much tweaked other stuff. One of which was stucco, which is just a huge issue in this area, but also nationwide. The disclosures are a little more detailed. And as far as I'm concerned, after defending countless stucco cases, I think this is good for both buyers and sellers. We both noticed solar powered electrical systems is now listed, and whether there's a lease involved or financing agreements or other agreements, power sharing agreements. And lastly, there's a section added with regard to swimming pools, which is good to have, to know what you're getting into with regard to that.
Yeah, and one I just thought of too that's been helpful is windows. Windows was never on there too, and that's always a question of how old are the windows? What was replaced? So they added that.
Which is important because that's often a source of water infiltration. I'm going to try to pronounce it properly. Um, all right. How about let's recap what we feel are some of the best practices for sellers and real estate agents with regard to the disclosures.
Yep.
So, and some of which we talked about before, some of which we talked about today. Number one, we feel you should use the Realtors form for seller disclosures that was just amended. It's more inclusive than what the law requires. But as we discussed, I think it's the best practice for sellers, for realtors, and ultimately for buyers.
Yep.
We talked about this before, and sure enough, the edits came about. Have sellers search their records for property maintenance, repairs, warranties, and attach that to the disclosures. Number three, and we did this really more from the last time we were together from a buyer's perspective and due diligence. But what I like to say to both sellers and buyers is get the property file from the township. These records now mostly are digitized, so a lot of times you can just email the township. And for instance, I just did it on my own house to see, what was done prior to my ownership and what I had done since I owned it. It's already been 15 years and I forgot some stuff.
Right.
So the property file is a great way for a buyer to learn a little bit more about the property, and for the seller to help complete the disclosure statement. We talked about this, and I can't stress it enough, are on the side of disclosure. Most people think these disclosures will impair their ability to sell. But as Kelly and I know, well, first of all, I don't care whether the market is hot or cold. Anyone other than a first-time home buyer knows that there are issues with a home. Every home has issues.
Right.
So I don't think if your concern is it's going to scare people off, so be it. You don't want that buyer. But to me, the more important thing is you don't want to get sued down the road. So you just disclose everything and you do a little you do go above and beyond what is required to make sure those disclosures are as thorough as possible. We didn't discuss this today. We discussed this last time, but I used to frown upon mediation, which is in all the standard Pennsylvania Realtor agreement of sale contracts. They all include a mediation clause. And just like the lawyer did with the executor, I like to just strike. I used to strike mediation. I don't anymore. I think that is a good provision. And I have settled quite a few cases at mediation, which I assure you is a lot less money than litigation, both the settlement value and attorney fees. So I think the mediation clause is important and should be utilized. I've even had people who have filed lawsuits and I have compelled them to mediate because if I can file a motion to force them if that provision is in that contract.
Right.
When we were preparing for this, Kelly and I were talking about one of the latest trends in real estate, which is buyers waiving inspections, hoping that that will make an offer more appealing to a seller. And I'm seeing this from an attorney side as well. And what Kelly and I were discussing is I'm not a big fan of this especially from either seller or buyer's perspective. Um, I think the better practice is to permit inspections. You know, you can always say you can inspect, but there will be no concessions for anything that's discovered, or, you know, any concessions are capped in a number. When buyers waive inspections, the seller does not have the defense if a lawsuit is filed that the buyer performed an inspection. That is one of the best defenses I have in seller disclosure cases. You know, that's out the window if the buyer waives it. And I think that benefits seller. From a buyer's perspective, this is probably the biggest investment you'll make in your life, right? Purchasing a home, and waiving an inspection is sort of you're going into it blindly. So I'm seeing this a lot. I understand the rationale, but ultimately I don't think it's in either seller or buyer's interest. So I think the better practice would be to permit the inspection and either make it clear the house is being sold as is, if the seller has that leverage, or agree to some type of cap, you know, on the numbers.
Got it. Understandable. And yeah, it's a risky thing. So just a quick question for realtors, for us, what is the best way to help my sellers when doing this form?
So I think the best way to help sellers when completing this form is to regurgitate exactly what we said today. Number one, err on the side of disclosure. Number two, search your records. Retain, search, and produce. And number three, have the sellers complete it themselves in their own writing. Realtors can assist, but I think when realtors assist, they are then exposing themselves to seller disclosure lawsuits. So ideally, not ideally, it needs to be the seller and only the seller. I think realtors, the best way you can assist is encourage to err on the side of disclosure and explain that these disclosures are not going to torpedo a deal.
Yeah, that's helpful. This is all very helpful. Any last notes or tips that you want to share?
So last time, you know, I don't want to get too much into the doomsday scenarios, but we talked about lawsuits and
That's when we need
exposure.
you as our doomsday
Right.
stuff, you know?
That's right. Well, I like to do these things so you don't, or to avoid these, but you know, here's the deal. Sellers typically do not have insurance coverage to defend these lawsuits. Realtors do, but sellers do not. So the first thing I would say is with sellers are, you have to understand your exposure is if you had knowledge of something and you didn't disclose it, and basically you get caught, you know, you're on the hook not only for the damages, which is what it takes to remedy this, but also attorney fees, which is big. So, and these cases are very expensive, any cases, but these cases are very expensive, and 9 out of 10 of the sellers that I represent are doing so without any insurance coverage. Close to 10 out of 10, because I only had one case where there was. So, you know, there's a lot of exposure. So again, I think I can't stress it enough. I think it's in everyone's best interest, buyer, seller, realtor, broker, that the disclosures be thorough, complete, and honest. And then everyone can sleep well at night.
Right. And it's, I mean, in my last 2 sentences, buyers to really review it and understand it. And if there are questions, I mean, we ask the seller if we have questions about stuff. So, and that's before the offer process, you know, you should be reviewing it before. I like to often send when possible before even seeing the house, just so you know what we're getting into up front. So,
Sure. And again, like we said, do your due diligence. The information is readily available. I don't rely to what I would say to buyers, don't rely on a seller disclosure. It's just one tool in many. And again, that file from the township, not that everyone pulls permits when they do work, but that actually might be a good step, you know, before even an offer is put in.
that's true, especially depending if you know it needs a lot of work or something up front. And that's called the right to know, right? When you
So
call the township, it's right to know.
like freedom
Make-
of information,
Right.
I'm not quite sure. Yes, I think it might be right to know, but I just had this with Plymouth Township, and I just emailed the person, and in an email format sent me, you know, they scanned all the records, and I have it in a PDF, so I could just go through, and I'm representing buyer. And there was substantial work done, that, and I'm not even sure if he got a disclosure yet. It was, hey, I'm interested in this house. It's on the
Right.
market.
Public record. Right.
Public record, you know, hey, let's search and, you know, see what's going on. And there's a pool, and there were issues, and a sewer, there was replacement of the sewer line. So these are all things that, you know, it's good to know and really easy to get that information.
Yeah, and that's a good tip you said too. You just pulled it on your house. Like if you've lived in your house for a while and you're planning to sell too, and you've lived there for 20 years, 30 years, you might not remember what you've done over the years. So
I forgot we replaced our roof, and I forgot what year it was. And so I got the
you
file.
forgot that bill. You forgot that big ticket.
Yeah, I didn't forget the
Cost.
bill, but but I know it's only good for 20 years and I'm coming up. So I wanted
Okay.
to know, you know,
Yeah.
before it rains on my head. So
Yeah. Good to know. Well, this is super helpful. Thank you so much for being here and sharing your information and being such a good resource.
thank you. And as things change, we'll do a follow-up.
Of course.
Thank you,
Thanks.
Kelly.
Bye.
All righty.